In this video, we're breaking down Section 27, Mediation, one of the most important dispute resolution provisions in the entire residential purchase agreement. This section, 1, explains what buyers and sellers must do before filing a lawsuit or starting arbitration. 2, outlines how the mediation process works under the RPA. 3, describes the role of the Car Real Estate Mediation Center. 4, clarifies how mediation fees are shared between the parties. 5, highlights the serious consequences for refusing mediation. 6, shows why skipping mediation can cause a party to lose the right to recover attorney's fees, even if they win. 7, provides a step-by-step breakdown of the mediation requirements. By the end of this video, you'll understand why mediation is mandatory under the RPA, how it protects both sides, and what agents need to explain to their clients when disputes arise. Let's get started with Section 27, Mediation. Section 27A, Main Mediation Agreement. 1. Parties agree to mediate disputes before arbitration or court. The parties agree to mediate any dispute or claim arising between them out of this agreement, or any resulting transaction, before resorting to arbitration or court action. Plain English, if there is a dispute arising from the purchase agreement or the sale, buyer and seller promise to try mediation first, before filing an arbitration claim or lawsuit. 2. Where mediation will take place. The mediation shall be conducted through the Car Real Estate Mediation Center for consumers or through any other mediation provider mutually agreed to by the parties. A. Default provider, Car Real Estate Mediation Center for consumers. B. The parties may pick another mediation provider if they both agree in writing. 3. Mediation with agents. The parties also agree to mediate any disputes or claims with agents who, in writing, agree to such mediation prior to, or within a reasonable time after, the dispute or claim is presented to the agent. A. Buyer and seller also agree to mediate with their agents, as long as the agents agree in writing to participate. B. This is important if a client later includes an agent in a claim. 4. Who pays the mediation fees? Mediation fees, if any, shall be divided equally among the parties involved and shall be recoverable under the prevailing party attorney fees clause. A. Equal split. Each participating party pays their share of the mediation fees. B. Those fees can later be recovered by the prevailing party in a lawsuit/arbitration if allowed. 5. The big consequence: lose right to attorney's fees if you skip mediation. If any party commences an action without first attempting to resolve the matter through mediation, or refuses to mediate after a request has been made, then that party shall not be entitled to recover attorney fees, even if they would otherwise be available. In plain English, if you sue or arbitrate first without trying mediation, or if the other side asks for mediation and you refuse, you give up your right to claim attorney's fees, even if you win the case and the contract would normally give you that right. 6. Mediation applies even if arbitration is not initialed. This mediation provision applies whether or not the arbitration provision is initialed. Even if the parties do not agree to arbitration in the dispute resolution section, the mediation requirement still applies. Section 27B, Additional Mediation Terms. This paragraph cross-references Section 28, but there are 3 key ideas baked into the sentence. 1. Exclusions listed in 28B still apply. Certain types of disputes may be excluded from mediation/arbitration, for example, small claims or certain foreclosure issues. Those exclusions are described in the next section of the RPA. 2. Mediation does not waive rights under 28C. Agreeing to mediate does not stop either party from preserving their rights, such as filing a notice to preserve a statute of limitations, as allowed by the next section. 3. Agents' rights/obligations further detailed in 28D. The specifics of the agent's rights and duties in dispute resolution are explained in the disputes/arbitration paragraph that follows. Important phrase: these terms apply even if the arbitration of disputes paragraph is not initialed. To summarize, Section 27 says, mediation first, attorney's fees at risk if you skip it, and these obligations tie directly into the more detailed dispute and arbitration terms in the next section, even if the arbitration clause itself isn't initialed.